Hey, and welcome back to the Michael Cohen Show. As again, we are on our journey to 250,000. We're more than halfway there, so thank you for that. All right, breaking news came out that Judge Chutkan issued an order that basically granted an additional 3-week delay in the ultimate decision. You see, when Judge Chutkan just got this back, as of course we know, it deals with the Supreme Court immunity decision. Immediately, everybody began working on it. So I want to read from the filing, and then you're going to hear something else, and then my final reaction. So in this case, as I said, on August 3rd of 2024, and that's just the other day, the court issued an order that's scheduling a conference for August 16th and directed that the parties confer. That's where they meet, and file by August 9th a joint status report that proposes a schedule for all of the pretrial proceedings to move forward. This, by the way, is standard. This is standard operating procedure. The rest of it, not so much so. And so the parties conferred, which again just means that the parties met. And with that, the government continues to assess the new precedent. This is the part that needs to be discussed, because this is now having the government assess the new precedent that was set forth last month by the Supreme Court in the case of Trump versus United States. And remember what that was about: presidential immunity. Remember how I had said on other episodes, the presidential immunity decision is going to be a disaster to us all, including through consultation with other Department of Justice components. Basically, they're telling Chutkan that Jack Smith needs to discuss certain components with other groups there at the Department of Justice. And so, as it says here, special counsel shall comply with all the rules, regs, procedures, practices, and policies of the DOJ, including consulting with appropriate offices within the DOJ for guidance with respect to established practice, policy, and procedure of the department. And again, this all has to do with the Supreme Court decision. Now, although those consultations are well underway, the government has not finalized its position on the most appropriate schedule for the parties to brief issues related to the decision. They don't really know what to do. That's the whole point here. And so the government therefore respectfully requests, and that again is Jack Smith, requests additional time so that they could provide the court with an informed proposal regarding the schedule for the pretrial proceedings moving forward. And of course, the defense does not object to the government's request for an extension. Accordingly, the government requests that the court enter an order requiring the parties to submit another joint status report by Friday, August 30th, and continuing the scheduling status conference until a convenient day thereafter. The government is available any day after August 30th. Defense is unavailable on September 6th, the week of September 16th, and signed by the various parties. So why, my friends, is this important? The reason that this is important is because I had said it before and I will say it again. The Supreme Court, through that Presidential Immunity Act, is extremely troubling and it's dangerous. What is this now doing? This is just granting Trump additional time within which to delay the inevitable, which would be the trial in this case. And why is that important? Because so many people believed that if in fact that the scheduling order was put forth and it was done basically in a truncated period, that this case could actually have gone to trial prior to the election. That would have been something. Because again, what is this case about? It's about the Trump's and his campaign's refusal to accept the decision when it came to the election. It's election interference. And why is that important? Because we are coming up to another election. And it's like, I scratch my head sometimes and I say, how did we fall so far down this rabbit hole? How have we gotten to where we are at? And the answer is, I don't know. It just goes to show you one thing, that with a little bit, and I'm not talking a lot, a little bit of ingenuity and a whole lot of desire to delay, it's almost like you could do anything if you have the finances within which to do it, which, again, is unfair because there's supposed to be one set of laws. Now, I want to now show you a tweet that Trump put out. Of course, what is he going to say? That it is clear that this is on Trump's Truth Social platform again. It is clear that the Supreme Court's historic decision on immunity demands and requires a complete and total dismissal of all, caps of course, the witch hunts, the January 6th hoax in Washington, D.C., the Manhattan DA zombie case, the New York AG scam, fake claims about a woman I never met, a 40-year-old photo in a line with her then husband does not count, and the Georgia perfect phone call charges. The Democrat Justice Department coordinated all, again in caps, of these political attacks, which are an election interference conspiracy against crazy Kamala Harris and crooked Joe Biden's political opponent, me. Let us come together to end, all caps, all weaponization of our Justice Department and make America great again. There's so much here before we take this down. There's so much here that needs to be unpacked. First and foremost, Judge Chutkan's decision here will not, under any circumstance, require or deem reasonable complete and total dismissal of any of these indictments, any of these 4 cases. But Trump, of course, has to take it even further. He has to now include a complete and total dismissal of the January 6th hoax in Washington, D.C. case. All right, here's 2 next ones. The Manhattan DA's zombie case and the New York AG scam. Okay, let's drop this and take this down for a sec. Both of those cases have already been heard in a court of law. Remember the New York AG case before Judge Engoron and the Manhattan District Attorney case before Judge Merchan, before a jury, whereas the Engoron case was what's called a bench trial. That was before the judge only, both of which ruled against Donald Trump. He wants to now take this presidential immunity and basically give him immunity for anything that he does before or after he was president of the United States. He is interpreting, of course, even that radical Supreme Court decision very differently than I think anybody else, including the Supreme Court. I mean, this is truly Donald J. Trump. And so, my friends, again, what is this now doing? This Jack Smith, this government delay of an additional 3 weeks, it is guaranteeing that this case, the election interference case, will not be heard before the November election date. It is now absolutely 100% off the table, impossible to do. And that is a disgrace. That case, first of all, should have been brought sooner, and that case should have already been tried so that the American people could understand just how dangerous Donald J. Trump is to the election process. And with that, I will conclude. Vote polls 2024. Hey everyone. First of all, thanks for watching. I mean, we're going to be posting daily episodes with reactions and talking about politics. We'll be talking about everything, in fact. So please like and subscribe. Join us on this journey.